Okay, good morning. This panel is really all about the law around crowdfunding. My name is Eve Picker, and I have a platform called Small Change, and we are going through the process of becoming a funding portal. So although I'm not an attorney, I've spent an awful lot of time with attorneys over the last year, a lot. So I'm going to ask each of these guys to introduce themselves very briefly, and then we're going to talk about the very ample legal hurdles to give you a taste of the issues in this industry. So Anthony, go.
Hello. Yeah. Hi, my name is Anthony Zeoli. I'm a partner with Freeborn and Peters. We're actually right down the street. So it's good to have a conference here in Chicago for once. I do a lot of work with real estate, private equity, and I do a lot of work in the crowdfunding area.
Hi, I'm Georgia Quinn. I'm co-founder of iDisclose, which is a legal technology company. We automate the preparation and filing of crowdfunding legal documents that you file with the SEC. And I'm also a practicing securities attorney at Elinoff Grossman & Scholl in New York.
I'm Mark Lancaster, Chief Executive Officer of Great Lakes Fund Solutions. We are an SEC registered transfer agent and an outsourced back office for retail investment funds. We offer CrowdKey, which is a white labeled platform for people who want to run their own crowdfunding platform.
This is Scott Purcell, CEO of Fund America. We're not a platform or a portal or a white label or anything. We are the ones underneath them. We provide the services in terms of any technology-driven offering needs. We provide escrow services, AML, we have transfer agent, we own a broker-dealer that provides execution services. We're starting a trust company to act as custodian for private securities, a variety of things that are structural pieces of the puzzle so that the platforms, the brokers, the investment advisors, and direct issuers can do their thing and raise money online.
And I'm Mark Roderick. I'm the person who was
So I'm going to group questions into three general areas. First, we're going to talk about the industry in general and the legal hurdles there. Next, we're going to talk about issues that are very specific to developers and the things that they have to deal with. And then finally, I'd like to talk about the future and what we see coming down the road. So many of you have been involved in real estate crowdfunding from its inception, as we heard before. And I'd like someone to take this on, like what's different now than 3 years ago legally? And what's the biggest legal challenge for the industry moving forward? Does anyone want to?
Anthony. Well, what's new is we actually have, some best practices that have been there 3 years ago was extremely the Wild West, in terms of documentation and what you've seen. So you're seeing some very sophisticated documents, some very good best practices coming out, so that's really good. As far as, what was the second part of the question?
So, what's the biggest legal challenge, do you think, for the industry moving forward, legal?
It's trying to take antiquated laws and make them for the new internet age, or the new structures that we have. The ability to advertise these things online. We have to kind of fit them into antiquated securities laws. So it's just getting around those. In terms of real estate, the biggest hurdle I think is not so much legal, but just the timing wise of getting through the legal part of it and getting to the point of actually raising money.
Also, what you see real estate people taking advantage of with the new regulations is amazing. The things that are being done today that weren't done even a few years ago. One of our customers is Rich Uncles, which is a project of the chairman of CBRE. It's $1 billion REIT. It's an S11. It's not a Reg A. It's a full REIT. And they are advertising on radio commercials all around the country and bringing in tens of millions of dollars from retail investors. That had never been done before. All online, pressing a button, investing, to Mark's point, reading the documents carefully, and putting money in. So REITs had never done this before. And then we've got Realty Mogul has a Reg A REIT, another customer of ours, and they're marketing it directly to the crowd and everything being done online. And then we have many real estate developers, some like MHP, which is raising a $100 million fund, again, online, marketing like crazy to people, to we've got a group out of New York, Fund That Flip, They literally open an escrow every single day of the week, including sometimes on weekends, for $75,000, $100,000, $200,000 offerings. So you've got a broad spectrum of people in the real estate community using the new rules and technology to raise capital. It's exciting. But the legal ramifications of that are crazy.
Can I just say, I think the answer to what has always been and still is the biggest legal challenge in this space is broker-dealer stuff. That's the question that comes up all the time. How do I charge transaction-based compensation? How do I take commissions for raising all this money that is started as a trickle and is now not a flood, but is a bigger trickle?
Yeah.
And you know, who can get paid for making that happen?
Right. Okay. So Mark, why do you think real estate is so popular in the Title II crowdfunding world? And do you think it will also dominate Title IV and Title III?
I think it's very likely.
Wrong Mark, sorry. I meant that for Mark Roderick, but that's okay. Go ahead.
I think that's very
I forgot
likely.
I have 2 marks.
I mean, I think that I think it's pretty obvious, although I don't have any hard numbers to back it up, why real estate immediately became the #1 asset class in crowdfunding. The reason is because I wrote a blog post. No, I actually did, but it was pretty obvious that when you're investing with a click of a button from afar, and you have a bunch of choices, and some of them are xyz.com, a new social media app, and another is this, another social media app. And then over here, there's an apartment building in Austin, Texas that is throwing off an annual 7% cash-on-cash return. That's easy. Seems pretty safe relative to everything else. And I do absolutely think that, I'm not sure about Title III. I'm not sure, because Title III
You're saying that to me?
might become Title III might become about local businesses and social impact kind of businesses. So I don't know about Title III, but I'm pretty sure Title IV will very quickly become dominated by high quality real estate assets.
Okay. So then Title III, Georgia. How many successful Title III crowdfunding deals have you seen so far? Can you give us some statistics?
Okay, so I have my legal pad with the latest stats, and these are based on yesterday's closings. And I don't even know if we have gone through like the different titles, Title II, III, and IV. Title III is the newest of the regulations to come into effect. It allows for retail investment of up to $1 million in a project or a company on an annual basis. So,
And it only became live in mid-May this year, so it's very, very new.
From May 16th to date, we've had 35 successful deals out of 120 deals that have been posted, so that's about a 30% success rate. There has been almost $8 million of money that has been closed on. And there has been about $10 million of money that has been pledged. The reason there's a discrepancy there is because the way Title III works is you set a minimum target. If you don't reach it, you don't get any of the money that's been pledged towards your project. So that's the difference there. In the last week, there was about $512,000 that was invested in Title III deals. And total investors in closed deals, so total Title III investors in all the deals is about 10,000.
So I'm going to back up a bit because I'm not sure everyone in the room does really understand Title III. Who's not familiar with Title III? Okay, so Title III, the last piece of the Jobs Act to come live in mid-May, is really wildly different from the other two titles. It does set a pretty firm limit for issuers annually of up to $1 million, which is not a lot of money, but you can do something with it. But it also really limits investors on how much they can invest. Anyone over the age of 18 can invest, which is really extraordinary. And anyone over the age of 18 can invest with a credit card, which is even more extraordinary, I think. But you're also limited to what you can invest in any 1 year. So anyone can invest up to $2,000 across all platforms, however many deals they want to invest in 1 year. If you want to invest more than that, it's a calculation based on your net income and net worth. And I believe that even if you're Warren Buffett, you can invest no more than $100,000 a year. So it's a very different animal. It's probably the very closest thing to Kickstarter and letting people become investors instead of getting T-shirts given to them. So it's really different, and we're really early on in seeing this, and very, very early on in it being marketed, even earlier than everything else.
Georgia, did you just say 10,000 people have invested in Title III deals?
Yes.
Are those uniques?
Can you
I
use
don't know
some
if they're
mic?
unique. It's 10,000, because they have
10,000
been different
investments.
deals.
But
So if
how
I
many deals have been closed
35.
with 10,000 investors?
Yes, so a lot of the deals are
That is-
over, I mean, most of the deals are over 1,000 investors.
That is
And that's
incredible.
why no bank
So
needs to be escrow.
while some people on the panel, you know, Small Change has always wanted to be a funding portal, working in the Title III area. And for a couple of years now, I've heard a lot of attorneys say, don't be ridiculous, it's never going to work. I think you have to have faith in the crowd. Like, I think there's so many things that can happen with this tool that we haven't even seen yet. It's just a very different tool. So anyway, that's a little background. So you like that number, Mark?
I think it's a huge number.
Yeah.
I mean, for the Title II world to get from 0 to 10,000, this person might know, but that, I mean, I think Title II took a long, long time to get to 10,000 participating investors.
It took a while. It certainly didn't take a few months.
It didn't take, so this is actually
But you're not
happening.
seeing $100 average transaction sizes.
And in addition, there's a pretty stiff registration process, because Title III platforms really kind of almost work like broker-dealers. They sort of manage the whole process of putting investors together with issuers online. So they have to be approved by FINRA, which is a pretty difficult, burdensome process. And so far there are, how many platforms are approved? 15 platforms approved and others in the pipeline. So this number's going to really grow exponentially. Anyway, that's a little background. So I think in terms of about the industry, you know, that's probably partly the future. So, Scott, what is the SEC's attitude towards crowdfunding? Do they like it or do they hate it?
We speak to FINRA and the SEC a lot, including Tim White last week, right? You guys, Elenov's also our attorneys, and they had a call with them. They are, frankly, they're still getting their arms around it. They don't know. I think some of the expectation was that this would explode faster than it has, but regardless, it's still growing. FINRA, to become a crowdfunding portal, you have to become an SEC registered entity, and you have to become a FINRA member firm, just like a broker-dealer, and that allows them to take commissions on deals, which otherwise would not be legal. When FINRA first started approving new funding portals, which are not existing broker-dealers, just people who wanted to start a funding portal, then, like what Eve's doing right now, in the early days of 3 months ago, that they were getting that done in about 7 days. Well, in a couple of weeks. They were getting it knocked out pretty quickly. And now recently they've cooled their jets and they're really taking more time. And part of that is because internally they're still getting their processes figured out. There have been questions around the escrow process in particular. The SEC, just like states, assumed, oh, we'll say a bank is going to be escrow agent, and then they sadly find out that literally no bank in the country wants to be escrow agent, except for one bank that's only doing it as a personal favor to me.
I have two.
You have two?
Mm-hmm.
Okay, so get some, who in Boston?
It's like Boston first.
Bo- Boston Private Trust is doing it as a trust company, not the bank. They're owned by a bank,
I think the bank is now going to step in.
so they're trying to get that
In
worked
any
out.
case,
In any
that
case,
is the hurdle.
it's, long story short, there are a lot of hurdles. It's still evolving, it's still embryonic, and the regulators, just like us and everybody in this room, are figuring things out. How it'll be a year from now is very different than how it is today.
So Mark, in the middle now, how does crowdfunding mesh with the existing world of financial advisors and broker-dealers and transfer agents, et cetera, et cetera?
The meshing process is underway. We've heard about a registered investment advisor on the first panel essentially being compensated for crowdfunding deals. That I think there's going to be a lot of desire for people to get compensated on a commission or some sort of basis for bringing investors in. I think most of these investors aren't going in exclusively by looking at things online in their slippers at night, that there is some voice interaction with them prior to investing. I think that the gap is closed a lot in terms of the investment knowledge in the crowdfunding industry, people realizing that this is offering a security, and there is a lot of movement in the mainstream industry, the 8.4 billion industry we spoke of earlier, the independent broker-dealer market, in terms of embracing technology, which is one of the fundamental, and the Jobs Act for sure, which is one of the fundamental characteristics of what has been known as the crowdfunding industry.
Can I
And,
add? I'm sorry, Anthony.
I was going to add one thing to that too. From the broker-dealer side, I've also seen and talked to some that are offering more of from the investor side, more value to their clients and actually advising them on these types that these offerings exist. They're getting the word out there because they see the value, and especially some of the real estate stuff, where it would fit into a balanced portfolio. So they are aware that these products are there, that they're legitimate, and that they're actually advising clients and building somewhat of a specialty in advising on these alternative investments.
And I just wanted to kind of double back and touch on what does the SEC and FINRA think about crowdfunding, just to make a really important point, which it kind of escaped me until I started really focusing on the selection and thinking about the current makeup of the SEC. And we are in a really important time for the SEC. Currently, the 5-commissioner panel only has 3 commissioners on it. And so this new president will be responsible for electing 2 commissioners, which will create a majority,
This could be huge.
Yes, so this is really important, and we currently have a lot of regulations trickling up through the SEC right now to kind of fix some of the issues that have arisen, the broker-dealer both on the broker-dealer side and on the issuer side, including this issue that we're currently facing with escrow agents and who's entitled. A lot of this is trickling up, in a legislative and regulatory sort of way, and it's going to come to a head, and it's going to be determined by these new elected representatives. So it's just, I hadn't realized that we're currently in this kind of void where right now nothing is really making its way through the SEC regulatory process because of the state of the commission, and we really need to focus on how we want that to look, and if we want a pro-business commission, or if we want, it's really dire and unfortunate for all of us.
My perspective just on that is the SEC has been fabulous from a 30,000-foot point of view, fabulous about crowdfunding. They have taken every opportunity to make it easier. There are a lot of decisions they had to make when they were issuing regulations under all the 3 flavors, and almost without fail, they have made the choice that facilitated crowdfunding, including, the choice about qualified investors under Title IV that got them sued by the states. The states were outraged, and that was just an enormous pro-crowdfunding step. Fine, let me just say about the meshing of the existing world. It's really complicated. The worlds need to mesh, that's for sure. On the other hand, crowdfunding threatens the existing world of financial advisors and brokers and Wall Street. It's the disruption. I mean, they're the yellow cab company, and crowdfunding is Uber. Or they're the hotel industry, and crowdfunding is Airbnb. So it's sort of, in some ways, like asking, how is Barnes and Noble going to mesh with Amazon? And
I think it's a really good way to describe it.
That's the big question. How much of it is going to mesh, and how much is just going to go away?
Well, or how much of it, how much is it going to influence what's been happening today? Because I think that's probably more likely to happen. We've got this amazing thing happening, and an industry that's been pretty placid, doing the same thing for very many years, and they're probably going to have to change the way they do business.
But they're changing because of FINRA, not because of the crowdfunding.
Well, wait a little. Anyway, so we're going to move on. There's one other flavor of crowdfunding that hasn't been mentioned yet, and that is the Intrastate Regulations. So we have Title III, Title IV, Title II, and then because the states were really fed up with waiting for these titles to become live, they started enacting their own laws. And Anthony, can you tell us a little bit about those and how they work? And
Absolutely, yeah. So just going back through the flavors, you have Title IV, which is up to $50 million, so it's large offerings. It's a registered offering with the SEC. Title III is up to $1 million, where you can have accredited and non-accredited investors nationwide invest. Title II is your regular kind of private investment from accredited investors, but now can be done online. Along with those three flavors, there are different intrastate regulations that you could also use. Particularly here, the one that I wrote for Illinois, you can raise up to $4 million a year per project, and you can get both accredited and non-accredited investors as long as they're all Illinois residents. So how intrastate regulations work is that they offer the ability to do kind of these public offerings within the state. So they can be accredited, non-accredited investors, but they all have to be within the state. So the company has to be within the state, and so do the investors. So everything, like Vegas, what happens in Vegas stays in Vegas. What happens within the state stays within the state, is governed by the intrastate regulations. Some of them are more favorable than others. Here we have a $4 million, Georgia is a $5 million. Others, we're talking about the $1 to $2 million range on average. But I think it's, especially for real estate, when I was talking with the Secretary of State, we wanted to make the cap high enough to actually have some real effect for a real estate project, because $1 million wasn't going to get much done here in Illinois. So we were able to at least get them to say $4 million, and again, it's $4 million per project per year to do that. And accredited investors can invest as much as they want, in as many projects as they want, but up to $5,000 per project per year.
okay, well, I'm gonna wrap up this segment and move on to some questions for developers specifically about deals. So, did you want to say something else, Mark?
I was going to ask Anthony, how are you? I mean, Anthony did write that law. He is Mr. Intrastate Crowdfunding. Are you seeing deals happening under the Illinois law?
We actually have about 4 deals ready to go. We're trying to figure out, this is the escrow problem with having a bank. We've been just trying to figure out the bank portion of it, because yes, one mistake that I did write was that you still have to have an escrow and it's a bank. I didn't think it was going to be that big of an issue, and that was my fault. So we're at the point of breaking that escrow problem probably within the next week. We expect to see the first couple deals within the next 2 weeks. Hector Robes of Veslo is walking around. He's the portal that's having them come out. One will be a real estate offering, the other is an existing company offering.
Cool.
Does the escrow have to be in the state?
The escrow has to be held by a bank that has a physical location in the state. So they can be a national bank, but they have a physical location. We have Lakeside Bank, and we're working with Fund America as well for the transfer as the actual escrow agent. The bank needs to be here in Illinois, which we have Lakeside now. We're just working out the logistics. We expect that to be resolved in the next week.
So, for developers, Scott, if I'm a developer and I want to raise money, do I need to go through a broker?
Mark and I have blogged on this topic. Ask your attorney. You mean how to raise money, or do you mean?
So, just for anyone who's thinking about raising money through an offering, do they need to go through a broker?
You don't have to use a broker, and there are technicalities based on different exemptions, even talking about like the Illinois Intrastate exemption, and using that for up to $4 million to raise money for a project here from investors here. You don't have to use a broker. You don't have to pay a broker for that. So the choice is really, when it comes to the legal side of things, you should always use an attorney. I don't care how experienced you are raising money, because these things are technical and the rules change. and the attorneys say it on top of that. Have them review the documents, even if they don't necessarily create them from scratch. But whether you use a broker, you can market the offering yourself. General solicitation allows you to market the offering. You can go, we're raising money, and tell the world, regardless of whether this is a Title II, Title III, Title IV, or intrastate offering.
You have to be a little careful with Title III.
Not that careful, actually, but there's dispute on that. But where the transaction takes place, like in a Title III, has to take place at a FINRA member firm, whether it's a funding portal or a broker-dealer. But how you market it, who sells it for you, you can sell it yourself. You can hire a broker-dealer to help sell it for you. You can have investment advisors help sell it for you. You can have platforms which are just marketing vehicles, like Start Engine and Crowdfunder and all these other guys, help sell it for you. You can do this in a lot of different ways, and the most successful people, the most successful real estate developers, who by nature of what they do are serial issuers, you can have deal after deal after deal, are generally casting a wide net. They're selling directly to their own investors under these exemptions, and they're using maybe a broker-dealer to help find new investors, or a funding platform that's like Early Shares or something to find additional investors, or Realty Mogul to find additional investors. And so they're doing it in a variety of ways, and that is, we see a lot. Well, Fund America, we see a lot, because we have literally hundreds of issuers with thousands of escrows. But the most successful ones that are building a sustainable model are the ones that are using multiple ways to raise capital from themselves to others.
Well, that brings me to the next question. And can you use several of these rules at the same time to raise money, Mark, Roderick? Yeah. And anyone else who wants to jump in?
That is a very complicated question. So what Eve is talking about when she says several of these rules, for example, if I am raising money in a Regulation A offering, can I simultaneously raise money in a Regulation D or Title II offering? Or more likely these days, can I do Title II and Title III at the same time? And it's an extremely complicated question legally. Theoretically, the answer is almost always yes. It is somehow theoretically possible, for example, to raise money using Title II and Title III at the same time. Yeah, you can always use Regulation S. You can always raise money from the Chinese at the same time that you're raising money in any other way. But Title II and Title III are the ones where this comes up most often, because Title III, you're limited to that $1 million. But let's say you have a project that you need $3 million for. You'd really like to include non-accredited investors. So you go to Eve's platform and say, hey, you raise the $1 million from the non-accrediteds. I will do a separate offering under Title II for the difference.
Perhaps I'll even do both for you.
Or perhaps you can do both on Eve's platform at the same time. And theoretically, yes, but it becomes a metaphysical question as to how the investor got to the offering. So theoretically, if you can somehow, even though this is all online, somehow separate your two funnels, and make sure that the people who invest under Title II only heard about the Title II offering, and the people who invested under Title III only heard in the permitted ways about the Title III offering, then yeah, you can do it. But try to wrap your brain around that is how that is actually happening in an online situation, and it is very difficult.
One thing I wanted to add to that is just for the developers in the room, I mean, what you guys should just understand is that there are multiple different ways to raise money under these types of rules, and you can combine them. While it is a little bit logistically of an issue, these options exist way more than they did before, and you can use them in multiple different ways. For example, I'm sure some people here have been involved with large developments going into places where people don't really like large developments. Well, now you can kind of carve out this little piece for $1 million in this other separate security and get the people involved, and they're much more friendly faces at zoning meetings and zoning boards and things like that. There are ways to kind of combine all of these components to help you get to your goal more favorably. Even if you do your own, even if you already have your own kind of accredited investor list, there are reasons why you might want to take a piece and do the $1 million, or take a piece and give to other accredited investors online to keep priming your pump.
And so Anthony, let me ask you this question. Can
you use the mic?
Can I do a Title II offering and combine it with an Illinois-only offering for an Illinois product?
Yeah, we just have two completely separate classes of securities and whole disclosure thing. So that's the accredited investor piece, and if that's your 506B, then that's your people that are getting it, and they're getting that, and then you have your investor piece for just the Illinois side.
And here's why it's important, especially like for the audience. Let's say a real estate developer is raising money on Eve's platform with her Title III portal, not platform, her portal, as Title III, and one of the investors that finds it is a family office, and they put $100,000 into it. Well, that family office is not allowed to invest any more into any more Title III offerings for the rest of the year. But now they see another deal that they like, and they go, Eve, we'll put money into that deal too. Well, they can't do it on her portal. It's illegal. But if she
They can't do it actually on any portal.
They can't do it on any portal.
Because it doesn't matter where they invest, they're limited.
So, I'm just picking on her.
Yeah.
So she could then do it as a separate offering as a 506B or it would have to be 506C, and they could still invest that way. So
But then they have to be
you would want to have
accredited.
concurrent offerings.
One thing we're actually seeing in the market is people, rather than do the concurrent, they're doing an immediately consecutive offering.
Yeah.
So they'll do a 506B offering to accredited investors, and then on the day they close, the next day they'll launch their Title III raise. And the SEC actually really likes this because it shows that there's already been that smart money invested in the company, and then what they're now offering to the retail investors, something that has been vetted and maybe has a better potential for success.
But then I have a question around that, because so you do
I want to just tag on her point. It actually has been worked in reverse too, where you're using the $1 million to do proof of concept for the smarter money to come in after. So they do the Title III first, and then the people say people really want this product or this whatever, and then the other bigger money comes into.
But there's a regulatory nuance here that splits you two. As you just said, there's a 506B before the Title III. In your case, it would be 506C
exactly.
afterwards.
That was my question.
We're all geeking out here on terminology. Let me explain that.
But that's not necessarily true.
You can do private money investors after the Title III. You're just saying, look at all this money we raised, and it's still.
It would be challenge of proven negative.
Yeah, Thank you.
The SEC walks in and prove that no investor found out about this. Exactly. To prove that negative, you're never going to be able to do that.
But this is all why it's so complicated.
But we're geeking out here.
And exciting.
It's
money.
506D, what everyone in this room has probably raised capital under in the past, and and love, is now been split into two, 506B and 506C. 506B is the 506D that you know and love. 506C allows you to raise money from accredited investors only, no 35 non-accredited investors or anything like that. You can use general solicitation, which means you can have a blimp circling the Super Bowl and drop leaflets on the crowd telling you're raising money. You can, the investors have to be reasonably confirmed as to their accreditation. Now the difference is, if you're doing a Title III offering, it's public, people know about it. So you can't use 506B, which is no general solicitation. You cannot market the offering except to people with whom you have a pre-existing and substantive relationship. So if you do that before you publicly talk about your company raising money, as Georgia says, then that's fine. But if you talk about publicly you're raising money with Title III, and then after Title III you want to raise money from under Regulation D, you should do it as a C, because people might have found out because you were generally marketing the company.
Okay.
No,
It becomes a point of argument, but
it's a different offering. That's what you're taking.
It's a different offering,
Yeah,
but still.
There's a high probability that they will be integrated.
I think that's a lawyer question.
And notice we have 3 lawyers on the panel arguing about this. That's how
We argue about this stuff all the time.
Oh wait, Heather had something.
Yeah.
All right, so when you have an unaccredited offering, like Title III Intrastate, and you combine that with a concurrent Title II accredited offering, terms? Are the terms different? Class is different?
They could be,
Yeah.
they could be.
Right.
They don't
And-
have
Like I said,
to
they're
be
different
the same.
offerings.
Right.
They're different.
They don't have to be.
Right, okay. And then how do accredited investors feel sitting side by side with unaccredited investors?
Now, that's a commercial point, and,
They feel good.
I think they're gonna
we
feel
like more
great,
money
yeah.
in the deal.
No, they do feel good. Now, you're coming from, as we know, from the family office world. Those people don't necessarily
They
feel
don't wanna
good.
hang out with the riffraff.
But in general, once they get used to it, seriously, I mean, that is their point of view, but once they get over that hurdle, they understand that cash is fungible, and it doesn't matter where it came from.
We were approached by a major venture capital company that was funding $10 million into this company. And they decided that they were gonna do 9 million of it themselves, and they wanted to bring in $1 million from the crowd. So this is a professional organization, the name of which most people would know, that is deciding proactively that they want to bring other crowd into the cap table.
Yeah, just from a real practical point of view though, the big money, they're going to have an issue if the rights that have been given to the smaller investors are the same as the rights that they've been given. They don't want to be held up in any decision-making or potential sale or acquisition by some holdout, $100 investor. So that's the commercial bit that you're gonna have to get around, and then operationally going forward on a practical point.
If
So
they're not
Georgia-
wanting silent money, they're usually okay.
We're gonna move along, and Georgia, you're gonna, if you'd like to address what you think are the top 3 mistakes that people make when conducting a crowdfunding campaign.
Well, it's good now because we have like a little bit of a track record to see, but I'm curious to see what everyone here says. But the main mistake I've been seeing, and it's just heartbreaking for me because I see these really great companies with excellent management teams, fantastic products, and things that I really believe in. Some I've actually invested in myself, and it's just all about preparation. They do not go into it with a marketing plan. They don't realize that crowdfunding is marketing, okay? There is this huge legal component, but that is table stakes. You have to be able to energize your base, you have to be able to reach out to people, you have to have a message, something that's gonna hook people in and get them to come to that site and give you their money. And I think a lot of people have the build it, they will come sort of philosophy where if I post it on the internet, someone will come and give me free money. And it just, time and time again, it does not work. And so for every, I've heard some different things, like for every $1 million you want to raise, you need to devote at least 100,000 to marketing. I don't know if that, ratio is really right, and I don't know if it's like a monetary thing or just like a blood, sweat, and tears kind of hard work thing, but you need to be able to get out there and sell your concept and have something, that resonates with people and gets them to do more than just look at your video online, but gets them to actually open their wallet.
So how do you then differentiate yourself as a portal? So if I'm an issuer,
We have an entire branding hour coming up later. Can we hold that question? He's asking how to differentiate yourself as a portal, so, yeah.
So you said the mistake was lack of preparing the package.
And just the general understanding that this is a marketing
What
tool.
happens to these guys when that fails? You're calling it out as a number one mistake.
Yeah, what happens is they don't get
They don't
any
raise the money.
and their deal is bust.
Money goes back from escrow to
Yeah.
the investors.
The money is returned from
Money
escrow.
goes, so if you only got part of it,
It all goes back. It's an all or none game.
So then
And
now they gotta go through the whole process.
they've got to,
try-
yeah, they've got to go find, and with a blemish on their record that says, we did this in a very public way online, it couldn't cut it.
Doesn't know how to market.
We had a Reg A issuer that had set the minimum too high for their offering, and by the time it hit the minimum date that they had issued with the SEC, they hadn't quite reached that minimum. We had to refund 1,100 investors from escrow. It was sick. And then
So-
they quickly refiled and trying to get those investors back, but they made mistakes in, they made mistakes in the way they'd done the legal, and so we had to refund the investors and they had to start over. And they set the minimum lower next time, and now they're getting disbursed.
So that's my number 2 biggest mistake, is setting just a minimum that you really can't reasonably expect to hit. And it's a fine line you have to walk, because you don't want to set a minimum that's so low you can't execute your business plan. That would be, misleading and potentially fraudulent. So obviously you have to, explain to investors what you're going to do with that money and how it will further the business. But you need to have reasonable expectations when you set that minimum amount, because again, if you don't hit that target, you get zero. And then I think the third thing is just not being flexible. And this could just be because we're all still trying to figure out the market and understand what it is that investors in this space are really looking for. But just because you went out with, a convertible instrument that had this coupon and these terms, you need to be ready to maybe shift and offer a different type of security, or add perks to your offering, or just take a different tack. And the regulations make it a little more difficult, because every time you make a material change to your offering, and even I kind of discussed this earlier, every time you make a material change to your offering, you have to go and get reconfirmations from all of the people that have currently pledged money. So you want to be careful about doing that, but also if your options are, that this is not going to be successful and you're going to get zero, you need to go and be willing to make those changes and adjust as you go along.
I'd add one more thing to that list, and that's deal structure. A lot of people are going out with a deal structure that investors just don't care about. I'm an accredited investor. Do I want to invest in equity offering of a startup company? Hell no. Nobody in their right mind does. But yet most people.
I'm in the wrong business.
No, but in terms of convertible note or debt or something with some kind of a defined exit strategy, which again was why I think real estate's doing so well. Yeah, absolutely. I'll put money into that. So no angel would put money into just as an equity deal in an early stage company. They do it as convertible note. They have some defined returns. They have some liquidation preferences. They have some things, and yet most of the crowdfunding portals in particular are going out there with companies, small companies, that have no real exit strategy, that have no way to define what's going to happen for investors, and yet they're encouraging these people to offer equity securities. Absolutely ridiculous, and so investors, by and large, aren't stupid, and they're just not buying the deals.
I'm going to change tack a little bit and just talk about, we've been really upbeat about real estate, but what happens when the real estate market declines? What happens to these funding portals and the deals? And who would like to tackle that question?
I'll jump on in a second. Before I do that, I definitely want to tag on something that Georgia said from the mistakes I see make. Preparation is the biggest mistake, and people, especially real estate guys, wanting to jump into this when, a week out from needing the money. They need to understand the structure, get their marketing plan in place, talk to accredited investors as to the types of deal terms that might be foreseeable. Get yourself ready to do this when you are ready to do it. It's not something that you can turn around and flip on a switch and in 2 weeks you're starting to raise money. It's just not going to happen. And everybody gets annoyed that isn't the way it is. So you kind of have to wrap your head around the process before, especially with the real estate guys in here. You guys are deal guys. You got to get this done. Know what you're doing way ahead of time before you actually need it.
Okay, so we're talking about, what happens if and when the real estate market declines?
I think that, that's a good question, but hopefully that doesn't end up soon. But I mean, with real estate is always an investment class that goes up and down, and I still think that there will always be, a desire for real estate investment in real estate. And again, this goes back to Scott's point. What investment do you have? Do you have an equity investment where you're going to lose your shirt? Do you have a debt investment where it has some exit, where you can get out and then maybe not reinvest or things like that? So I think as we see more debt types of instruments coming from the real estate, at least people will be a little more, I wouldn't say protected, but they have a little less of an exposure.
So I would tag a question onto that because it's something that I've seen. I think that the crowdfunding market doesn't really quite understand what a real estate investment looks like. You make much more money in real estate if you just stay in for the long term. But it's pretty hard to sell something that's longer than 5 years, which is really not the way to make money in real estate. So I think that's also part of the equation here in this emerging market that really hasn't matured yet.
There's always been silent money too that makes less than that, back end percentage. Typically it's probably about 25%, at least with the crowdfunding, they're down to somewhere between 12 and 14%. So I think it's just a matter of risk versus reward. The crowdfunding investors are putting in less money per person so they don't expect as much. And yeah, obviously the astronomical upsides are with the equity being in the long term. And I think, as investors become more comfortable with this type of investment, that they'll later be able to branch out into those type of longer term investments.
Yeah, and Eve, I would just say, this is up to us. I mean, this is an education issue. I think Jordan touched on this on the earlier panel, but we need to teach people that the best way to invest in real estate is to do it for the long term. I mean, this is just, we're now accessing a whole new group of investors that have never done this before,
Right.
so.
That's right.
I mean, your question, what's going to happen when, not if, the real estate market
Exactly.
turns down? This is a hugely important question. I'm not sure how the platforms are going to deal with it, and I'd be interested to hear Heather, for example. It seems to me that investors are just going to stop writing checks, and I don't know how long the existing platforms, all of them, Fundrise, Realty Mogul, I don't know how long they can stay in business if investors stop writing checks. It's not that these are billion-dollar financial institutions. So when the downturn comes, I think it's going to have an enormous effect on our industry. Now, how do those people plan for it? If you're in early shares, how do you plan for this coming downturn? Is there some derivative financial instrument that, when the downturn hits, you say, oh, well, now we're selling this because this is a perfect security for a down market. But
one really good example of that is 2009, the value of investments declined rapidly in suburbs, but even in cities like Pittsburgh, in the inner city, the value of real estate increased during that period. So it may be more about what where you invest. I don't think you can talk about the entire real estate market in the same way.
But
Yeah, it's
for example,
relative to what? What are other investments doing? Because people are always gonna seek yield and always need to put their money somewhere.
but they
so-
don't. I mean, retail investors, when the economy goes down and the stock market goes down, what do they do at the worst possible time?
They put their money under their mattress.
They sell. And mutual funds have liquidity crises because people stop right when they should be investing. Not only do they stop investing, they
pull it out, yeah.
They start pulling money out, and I just don't know how today's platforms will survive even a short glitch in their income streams.
Okay, well,
A lot of the platforms are, the broker-dealer platforms, the ones operating on a commission, I agree they've got a problem. Because what will happen is the time horizon, the hold horizon will get longer. We have Houlihan here in Chicago recently underwrote a real estate deal here in Chicago that this was 6 months ago, it got funded. We're now, because we processed the payments, the investors are getting 175% of their money back 6 months later. So that's a quick addiction to short-term stuff. iFunding, same thing. A lot of early shares and Eve's portal and platform and all stuff she does. You get really good returns. People get used to 20-30% IRRs in the real estate sector. Well, that becomes less and it becomes long-term. But so they don't have the money to continually to reinvest. If the platform is operating on a broker-dealer style, getting commissions, well, without being able to churn that money, they're not going to get any commissions. But operating as an investment advisor model where you're getting a 2 and 20, then you're kind of smiling because you have a longer 2% hold time on those funds, and any of the gains that are coming through, you're taking your 20% on. So you can make money on your book as a platform if you build it now, even if the investor's time horizon stretches later, if you're doing it as an investment advisor model.
so I want to end on a sort of slightly happier note, and then we'll just take questions if you don't want it. I have one more question, and that is, do you think that the SEC will make significant changes to regulation crowdfunding at the end of the trial 3 years? The regulations that went live are really meant to be a 3-year trial, and there were a lot of complaints about the limits on issuers in particular. So
Yeah, so I think that before the trial period is over, there are going to be some significant changes from the congressional level. There are currently about 5 bills that have been either passed by the House or in committee in the House and going to move to the Senate. Again, the election year's kind of thrown a monkey wrench in all this, but there are definitely some changes that we can look forward to seeing. I do think it's going to be really hard to tell.
And what are the changes? Can you tell us?
The biggest change, which is really going to help real estate, is the ability to use an SPV when doing a Title III deal. So right now, the Title III deals have to be structured as a direct investment. The investor has to actually own the securities of the issuing entity, which would likely be the property holding entity, which is hard for a real estate deal. Usually you set it up in an SPV, multiple SPVs can then invest with different terms in the capital stack of a real estate investment. So that makes it more challenging, but now the ability to use an SPV would allow a Title III deal to look like any other deal, and then you could very easily tack on a small piece of a much bigger real estate project. So, a multi-million-dollar real estate project, you could just tack on a little, $1 million crowd component. So that's one of the major changes. Some of the other changes are the ability to test the waters, which would allow you to publicize your deal and just get indications of interest to see if it would even be successful before going to all the trouble to launch it. Another change is clarifying the regulatory and the liability, the scope of liability that is faced by the platforms. Right now it's just not quite congruous with the current law, so it's just kind of making, ameliorating those two bodies of law. It's really geeky, sorry, I should have mentioned that one. Just
raising the cap.
Pardon?
Raising the cap.
Oh yeah, raising the cap, which, to be honest with you, I don't think that's, in 5 years from now, I think we should definitely we'll be ready to raise the cap. But right now, the deals that we're seeing getting funded are averaging $200,000. So it doesn't seem to be a real need and an impetus right now.
Isn't that because there's $1 million cap?
Yeah.
I mean,
if I just said they were $996,000, then I'd say, oh yeah, we're bumping up against the cap. But
you don't think if we had a $5 million cap now, we'd be seeing a lot more Title III deals?
A lot more real estate deals.
A lot more, perhaps. I mean, real estate is the area, but the average small business loan is $170,000. So I actually think that for small business, which is really what Title III is targeted for, which is why they have the SPV rule and all of that, I think that for right now, and especially as investors are starting to figure this out and understand this whole new concept, I think the $1 million cap, it doesn't bother me right now, but I think in 5 years it will.
Is anyone going to clarify advertising?
Well, advertising is getting pretty clear. I mean, we've gotten some memos and some pretty good guidance. I think what would help with advertising is the ability to test the waters.
Okay.
That's what will really change things dramatically.
So I think I'm gonna, if everyone doesn't, I'm gonna wrap up these questions and take questions from the audience. If anyone, yes.
You talked about a downturn in the economy.
Can you shout a little?
Yeah. In a downturn in the real estate markets, the impact on the platforms themselves and their viability. Is there an ongoing obligation they have to those investors that would be handled by a backup servicer agreement, similar to what Lending Club deals with, and in the event nobody shows up to buy their loans?
With some platforms, yes. Ottopia, who's the representative today from Patch of Land, do you want to actually talk for a second about your backup plan?
You know what? I think we need to give her a mic.
Can you shout?
Yeah,
Just,
is that okay?
yeah, just give her the mic. Yeah.
So we have an equity structure.
So even though we are issuing borrower payment dependent notes, they sit in a bankruptcy remote SPV where an indentured trustee would step in the case that the operating company goes out of business. So if you're an investor in that note, you're going to get service, you're going to get your payments, and everything's going to get taken care of regardless of whether we're still around.
So the real risk is the equity risk to the platform.
Yes.
Yeah.
If it's dependent on the
Yeah.
it's not to the investor.
Exactly. I mean, your risk is in the investment in and of itself.
Yes,
So is the
yeah.
borrower
I didn't mean to suggest that there was investor risk.
Right.
Because I think generally there is not investor risk.
Is that true across all of the platforms?
No.
No,
No
no,
requirement from the SEC that there
No.
are backup
No,
services
there's no
provisions?
requirement.
No, there's only, we were the first, and we made those docs publicly available. And you can find them on the website, patchland.com, legal, it's in the footer. And then there were other platforms, Realty Shares copied it, and Pierce Street, I believe, also copied it. And that was on purpose. We did that on purpose to make that publicly available, to create a standard for platforms.
Yeah, I would say that the top platforms and many of the non-top platforms, I mean, all the people I represent, and I represent lots and lots of people, use a similar, but somewhat better, but similar structure. Now, a structure that accomplishes that same thing. So I would say if you're investing on top tier platforms, then there is really no investor risk. Is that, would you guys
There are
agree
some-
with that?
There are some major platforms that still, especially in their vintage.
In their vintage deals.
Have a
There
lot
are
of
some-
balance sheet risk.
Yes, there are some older vintage deals, so don't invest in those.
Any other questions? One more question.
Steer clear.
Yep, go ahead.
Kind of to piggyback on that question of risk and is there a backup servicer, Tony, you mentioned something earlier about depending on the position the investor has. If it's, if it's equity, they could be losing their shirt. If it's debt, they couldn't. I wanted to make a comment on it. That
I wouldn't say they couldn't, I just meant that they're at least getting
yeah,
some.
less forward. While I certainly see the value in having that cash flow on the debt, in the real estate side, at least the equity position gives them some form of security on the dirt, the real property improvements. And so I'm careful about that. We found it very hard to kind of sell debt initially, especially on a new development. But there were quite a few buyers on the equity. And then the young lady in the back asked, how did the unaccredited guys feel next to the accredited money? And I think all you guys made a good point, but I wanted to reinforce that, hey, as long as the operating agreements are written in such a manner where
That's right.
The amended and restating operating agreements got to make it so that the small investors can't be a thorn in the side to the lead investor, and the lead investors can't be bullying the small investors in terms of the material parts of the deal, the disposition, the dev costs we hire, things like that. But overall, both parties in our deal, where we had 35 non-accredited investors, they were very happy to be investing side by side with industry money. And the industry money was very comfortable having their own attorneys review our amended restating operating agreement, seeing that, hey, there's a predefined strategy up front, and everyone's agreeing to that into the deal. And so, guys, crowdfunding, I think one of the emphasis lawyers are making here is that the legislation is allowing it, and some of the tools that are already available are allowing it, where non-accredited and accredited money stand side by side. The deal size gets bigger, whether it's part of the capital stack or the entire capital stack. It's allowing, you guys are allowing portals to, do some really iconic deals, some really institutional grade deals because of the combination of both dollars.
So we are going to wrap up, but I think suffice to say that we have barely scratched the surface here of legal issues, and the guys sitting here are the very best in the industry, and they're going to be here for the rest of the day. So if you have questions, please ask them. They're pretty friendly.